Are you automatically intentionally homeless just because you've got rent arrears? Now, it's alarming how many times I see professionals repeating this fallacy that yes, if you've got rent arrears, you're automatically intentionally homeless and there's no point making an application. That is wrong on several counts. But I'm just going to home in on this idea of intentionality and rent arrears, because as with a lot of areas of housing law, when you actually look at what the law says, it's very reasonable and it gives lots of details of situations which people often find themselves up in, which can lead them to becoming homeless. And obviously, cost of living crisis being what it is, you're going to see a lot of people genuinely not being able to afford their rent and their mortgage costs. And the fact of the matter is that within housing law, essentially what that means is they're not going to be intentionally homeless. But there's even more good news with that in terms of how else the law can be applied to different people's situations and the realities that people are actually facing. So if you've been told you're intentionally homeless by a council because you've got rent arrears, or in fact any reason, to be honest, it is always worth challenging. And I'm going to do a video quite soon actually about using ChatGPT to write the letters you need to write to challenge council decisions. Now, ChatGPT does not understand housing law, it seems, but it can write a good letter if you tell it what to actually put into it. So if you put the right input in, you'll get a very usable, very useful letter out of it if you kind of just bear with it for a little bit. As I say, I'll do that at some point. But focusing on this question of rent arrears and intentional homelessness, we're going to start with the Homelessness Code of Guidance. Now, the Homelessness Code of Guidance, as you've heard me mention many times on this channel, is the best resource around understanding homelessness law. It's freely available. If you just Google Homelessness Code of Guidance PDF, you'll get the most recent version. And it is the statutory, as in it's the legal guidance for councils in order to basically work out what housing law actually means and how they need to apply it in real world cases. So although it does use quite a lot of jargon, it is much more accessible than trying to read the Housing Act, for example, or trying to read a very technical textbook or something. So as well as LGSCO decisions on their website, this is a really good way to start to understand how housing law actually works. And as I say, although it's called guidance, it is essentially legally binding for housing officers as they undergo their duties under the Housing Act. So if you go to Chapter 9 of the Code of Guidance, it's all about intentional homelessness, and if you go to specifically 9.7, that's where we'll start here, and it sets out 3 criteria which all have to be satisfied for someone to be intentionally homeless. So if we just read it now, I'll put it up on the screen. So, definition of intentional homelessness, 9.7, section 191, subsection 1, so that's the Housing Act 1996 bit that this is now talking about, provides that a person becomes homeless intentionally if all of the following apply. Has to be all of them, can't just be 2 of them or 1 of them, it has to be all 3, which is significant as we'll see shortly. So A, the first one, they deliberately do or fail to do anything in consequence of which they cease to occupy accommodation. So that might be failing to pay the rent, committing antisocial behaviour, going to prison, abandoning their property altogether, all sorts of things like that. So they're kind of the main contenders for this. So the idea is that you would need to have deliberately done those things, but that in itself is not all 3 criteria, it's just the first criteria. And secondly, B, the accommodation is available through occupation, which is not something which is terribly useful, but this is the useful bit, the third part. And C, it would have been reasonable for them to continue to occupy the accommodation. And although the law can seem very boring and very pedantic, this term reasonable to continue to occupy is well worth getting your head around, because it's not just within intentional homelessness you see that wording, you'll also see it in the definition of homelessness itself. And actually if you go to section 175 of the Housing Act, I'm not saying you should do, but if you want to go check it out, it basically says there are 3 groups of people who are legally homeless. So the first one is people who literally don't have a home to live in, which is the most obvious one potentially, so people sleeping rough or sofa surfing. People who have accommodation but it's not available through occupation, for example, because they've been illegally evicted or they can't travel to it. But again, the third one here in that sense is the really interesting one. It also says that people should not be treated as having accommodation unless it is accommodation that is reasonable to continue to occupy. So that term that we're talking about here is also within section 175 of the Housing Act. And if you look at case law around this, you can insert the word indefinitely, I would say reasonably, fairly. So you would be homeless if you have accommodation, but it is not accommodation that's reasonable to continue to occupy indefinitely. And the kinds of situations that the law goes on to suggest there are people at risk of domestic abuse or other abuse, people who have really bad disrepair issues, damp and mould affecting their health, category 1 hazards, that sort of thing. It would also include people who have accommodation but it's not suitable for their needs. Maybe they've developed a disability or something and they can't now get up and down the stairs, something like that. but it also includes people who cannot afford their rent. And that's really what we're talking about here with rent arrears. Is what I'm saying is, and what the law is saying is that yes, people may well get into rent arrears, but that does not necessarily equate to being intentionally homeless. It's not that they've intended to end up in a situation where they've got rent arrears. It's just, because of the cost of living crisis, because of other issues that just come up in life, they have not been able to keep up with their rent payments. And actually, as I say, it actually gets better than this as we look into the kind of ins and outs of this. But if we just start with this idea that you cannot be intentionally homeless, or you cannot be found intentionally homeless unless the accommodation you lost was reasonable to continue to occupy, which leads us to this question of affordability may well have a bearing on whether it was reasonable to continue to occupy or not. Now, to illustrate this case as easily as I can, we're going to use a case called Samuels v Birmingham, which was a Supreme Court case, which is the highest court in England. I think it was 2019, or seemed to happen in 2018, 2019. I've seen the published document was from 2019. But it actually goes back to a case where this family lost their accommodation back in 2011. So it's a good example of how long it can take an ordinary family in England, or an ordinary person in England, to secure justice through the legal system. So although I think it was a very good outcome in the end, this family had to wait in temporary accommodation for years before they got to that point. And the story was actually picked up in the local press in Birmingham. So I'll put a little screenshot up there of the title. The actual article does a pretty good job of getting in the technicality. So I was actually quite impressed with the journalist who wrote that, because often when you see the media talk about homelessness, they get it all wrong. But they actually did a pretty good job there, and you obviously can check out the articles on the link on the description as well. But effectively what happened was, so her name was Terryann Samuels. So she was a single mother of 4 kids, and she had a learning difficulty as well, which probably made things even more difficult. And it doesn't actually say within the transcript I've seen, but this happened at around about the same sort of time that the benefit cap kicked in. Now, whether or not it was because of the benefit cap doesn't matter from what I'm saying, but I think that might be what's behind it. The benefit cap is something which the coalition government brought in, which basically set an upper limit of how much benefits you could get, irrespective of how many kids you had and how much your rent was. And there was a lot of uproar at the time in councils, because they were immediately saying, you idiots, you're going to make a whole load of people legally homeless overnight. So in approaching Birmingham City Council, she provided some figures in the course of it. So what I guess is she was sent an income and expenditure form, which is many councils use. So you basically set out what your income is, what your earnings are, what your benefits you're getting, everything else like that. And then you give an estimate for how much your essential living out costs are. And when we talk about that, when we talk about essential costs of living, we're talking about food, kind of gas, electric, water, phones, internet, because let's face it, these days you need internet to get by in life, travel, clothing, white goods, TV license it extends to. There's a few other things as well like that. So that's kind of what we're talking about when we talk about the kind of the bare necessities, the bare essentials of life. And housing costs are separate from that. So back in 2011 in particular, you would get housing benefit which would go towards your rent, and you'd get another payment from DWP which would cover these essential necessities of life. And in Miss Samuel's case, her rent was £150 more than what she was getting from housing benefit. And if you're in this situation, I'm sure you're familiar with situations where universal credit, or if you are still on housing benefit, simply is not enough to actually cover what your real rent is. So essentially you're having to try and find the money from somewhere to top that rent up. And when Miss Samuels filled in that income and expenditure form, she basically didn't do her homework particularly well. Now, there might be a number of reasons for that. One might be because she's got learning difficulty, but she basically estimated that she was spending about £150 a month on food and other kind of household costs, and then her overall cost, including things like utilities, was about £330 or something like that, which was a massive underestimate. No one, even back then, you weren't able to get by with that amount of money. And the housing officer in Birmingham essentially said, well, look, yes, there's a £150 shortfall, but you're receiving whatever it was, therefore you should be able to find that £150 from that money to top up your rent. And that's the question that kind of went through the courts to get to the Supreme Court. And essentially, without going into too much detail, what the Supreme Court essentially said in this case was that when the DWP calculate how much money to give people, it is only ever supposed to be enough to be a subsistence, basically, enough to cover those bare essentials of life. It's not going to be money that you can put towards your holiday, because that's not part of the calculation that's actually kind of put out there to work out how much money to give you. And so when Ms Samuels received however much it was from income support and child benefit and so on, that was specifically only ever supposed to be for those essentials of life, those the food, electric, clothing, travel, all that sort of thing. It was specifically never supposed to be for housing costs, because housing costs are supposed to come from housing benefit. And in a sense, it kind of made the decision quite easy, because Birmingham were expecting her to pay money that should have been for food and gas and electric on her rent, and essentially the court is saying that isn't reasonable. And in fact, the headline from the Birmingham local press release or article was that mother chose to feed her kids over paying the rent. And essentially what the judges in the Supreme Court case said was, yeah, that's fair enough, that's pretty reasonable to do, and therefore the accommodation she was living in was not reasonable to continue to occupy. Therefore, according to 9.7 of the Code of Guidance, she cannot be found intentionally homeless. And so Birmingham basically had to accept the full duty for her, and presumably would have housed her at some point afterwards. Now, a couple of confusing bits with this case. One is that the Homelessness Code of Guidance wording changed around about 2018. So when the Homelessness Reduction Act came into force, they reworded and kind of rejigged the Homelessness Code of Guidance. So if you're looking at the transcript, bear in mind that the paragraph numbers in the case are different from what the existing Code of Guidance is, because, as I say, they swapped entire chapters around in some cases. And after, I'm not quite sure the timeline of events, but the wording of the new version of the Code of Guidance, whether it was based as a result of this actual case or whether it was something else, essentially weakened the position slightly. So this was brilliant law for about 5 minutes until the new Homelessness Code of Guidance came in. And what they basically changed was, rather than saying local authorities should use DWP calculations as a good starting point, as a robust starting point, it basically changed it very slightly to saying local authorities may want to use the DWP figures as a starting point. Now, that softening of that wording has not been very helpful at all. And actually what's happened since Samuels v Birmingham is that BAPT v Kingston also happened, which I think was around about 2021. I've not even checked recently, but basically another case about affordability, another case where the local authority housing officer was trying to say, well, I think you can basically pay the rent, and that's the end of it. And again, I'm not even quite sure how it all worked out. So I've read that case many times. I even went on to nearlylegal.co.uk, so Giles Peaker's blog, and put a comment onto the article he did about this, basically saying, I'm not quite sure what this even means. And he basically came back and said, yeah, I'm kind of a little bit confused myself. So it's not just me being confused. If Giles Peaker's confused, I'm probably in good company. But what seems to be the case is that nothing in the BAPT case particularly undermined what the Samuels judgment was, and certainly hasn't undermined what 9.7 of the Code of Guidance says. So the question of affordability, I think, is still a little bit of a grey area, because Samuels was good, BAPT case was confusing, and I'm not sure if there's been any cases since then. But largely what I'm talking about from the Samuels case will hold true today, even though it's, whatever, it's six years later or so. And so what you really want to focus on is what your income actually was for the period that you were in that accommodation, and how much your rent actually cost, and effectively how much the shortfall was. Now, you will notice that lots of housing officers love to go through bank statements and kind of pick out things which they don't think you should have spent money on. But that's actually not the question they should be asking. The question they should be asking is, was the amount of money you had to get by in life, was that enough to pay for your essential living costs and also cover the rent? And as I say, in the cost of living crisis world, in many cases it simply won't be the case, and often they'll be quite straightforward. I mean, the amounts of shortfalls you'll sometimes see are in hundreds and hundreds of pounds. One of the most significant cases I worked on in Bedford was in a situation where a family was actually £800 under what they needed, and yet Bedford Borough Council still managed to try and say they're intentionally homeless. So as I say, you really want to be looking at the actual bare facts. You don't want to get into an argument with the housing officer about what you should and shouldn't have spent money on. In one sense, if you didn't have enough money to get by, it's clear that that's objectively true, and you were spending all your money on takeaways, that actually doesn't change the fact that you're not intentionally homeless, because it's not a question of what you actually spent your money on. The question was, did you have enough money to actually cover those costs as you went through? And as I say, this word indefinitely means, it doesn't mean eternally, but it means kind of for the foreseeable future. So I'm hoping that gives you an idea of how the law actually works around intentional homelessness and rent arrears. Now, I don't know for sure how many times councils get this wrong. I don't want to say that it's more than half, but I would say that a very large number of times councils see that there are rent arrears and they immediately jump to that conclusion that you're intentionally homeless, and they won't even really engage in the nitty-gritty of what they need to apply themselves to work out if you actually are or not. But as I say, 9.7 of the Code of Guidance is really key. And going back to that idea of using ChatGPT to challenge councils on this, effectively, if you go to chatgpt.com or some other AI thing, if there are other ones as well, and you basically say, please write me a letter to challenge a Section 184 decision that I'm intentionally homeless because the council said my accommodation was affordable and I don't think it was, and here's my reasoning. And you might just lay out some figures. You might say my income was £1,000 a month, but my outgoings were £1,200 a month or something like that. You'll be surprised how well, how coherent a letter it will write. Now, you might then want to tweak it and stuff and kind of, make it better, but that will certainly give you a good starting point. And actually, you could go back and say, please write me a Section 202 review letter following a Section 184 intentional homeless decision because of X, Y, and Z. And as I say, I've played around with ChatGPT a little bit, and it seems to be able to do a pretty good job of giving you that good starting point. Now, there are some other bits and pieces that might help you out in the code of guidance as well, but I'm not going to go into too much detail on them, so you might want to check out 9.17 as well, because it kind of reiterates the same point. But I would be of the opinion that all you need to do is show that the accommodation was not reasonable to continue to occupy, and therefore no matter what you did, you might have gone to prison, you might have burnt it down for all I know. The fact is, if it wasn't reasonable to continue to occupy, then you cannot be found intentionally homeless from it, however absurd that might seem. Now, it does seem a little bit absurd, and I guess I'd finish with this, because the reason that the law's been created like this is to protect people, say for example, who are subject to domestic abuse and they flee the property, because the fleeing of the property would be a deliberate act, as in it's conscious, it's not something that's kind of accidental. But the fact is, they still wouldn't be intentionally homeless because it was not reasonable to continue to occupy. So the same thing would go whenever you're working with someone who has been told they're intentionally homeless. One of the key things you always need to do is look at, was it affordable? And what you find with a lot of properties, not only kind of rogue landlord properties and kind of private rented accommodation properties, but even so-called supported accommodation, when you do the maths on how much they're expected to pay, service charges and so on, you can see that clearly it was never reasonable to continue to occupy in the first place, and therefore they cannot be found intentionally homeless from it. Even if they did breach the rules, even if they did do something illegal, the 3 criteria need to be met of 9.7, not just the first one. And that's going to be the thing which kind of actually changes a lot of people's situations around. And as I say, I guess the kind of underlying, as I say, it might seem absurd, but I think the underlying reason is that if you are living somewhere which it just isn't reasonable to be, then you can be forgiven for not paying the rent, or kind of not meeting the criteria that you're supposed to be meeting, because it's so intolerable. And I guess that's kind of what it's really set up to do. And yes, what it does mean is that occasionally you'll have people who probably do deserve to be homeless, if anyone does. You might have those kind of high level perpetrators of domestic abuse, you might have those kind of real kind of dangerous criminals. But even in those situations, you'd still need to check out, was it reasonable to continue to occupy? Was it affordable? Was it, kind of safe? All those kind of things. And unless the answer is yes to all 3 questions, they're not intentionally homeless. And so councils may well have a duty to house someone. Obviously, particularly in cases where we're talking about someone who's in priority need. Again, even kind of take this to the point, I heard of a case recently, which I'll try and anonymise as much as I can, as someone I used to work with, and therefore I kind of knew the person's situation over the course of several years, and I knew that over the course of several years they were subject to some pretty horrific abuse. Now, they also went on to kind of carry out some pretty antisocial behaviour, and in my opinion quite rightly got evicted for it. But the question of whether or not they're intentionally homeless will all hinge on whether the accommodation was reasonable to continue to occupy during the time they were there. And my own opinion of that, and we're about to find out if I'm right or not, is that the ongoing abuse that they were subject to over that time period means that they should not be found intentionally homeless. So, as always, if you've got questions about this, anonymise them. So don't ask questions like, oh, I'm in this situation and what happens if I do X, Y, and Z. Just say the question, what if someone had been found intentionally homeless with these circumstances, what would they be able to do? I'll be able to give you exactly the same answer. In fact, in most cases, I'll be able to give you a better answer. And what I'll do with those questions is I'll take them to the weekly live stream every Thursday evening, 7:30 p.m. You can tune in live. It's nice to have a bunch of people there. Actually, there's a nice little community there. But if you can't watch it live, just watch the recording on the live section of the channel. And effectively, I index the questions that have come through, and you can see where I'm dealing with your question. It just gives us the space to give a bit more of a nuanced response rather than trying to do it all in writing.